Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the final LawCast in a series talking about distributed ledger technology, also known as DLT or blockchain. In addition to the general information I have provided during this LawCast series, I have also been summarizing a report issued by FINRA in January 2017 discussing the implications of DLT for the securities industry, including FINRA member broker-dealer firms. In the report, FINRA specifically discussed some major areas of consideration. In this and the previous LawCast in this series, I have been going through each of these topics and summarizing what was contained in the FINRA report. Related to anti-money laundering and customer identification programs, DLT allows for global and anonymous participation, and accordingly, practices and regulations will need to address anti-money laundering, called AML, and customer identification obligations, known as CIP. The Bank Secrecy Act of 1970 requires controls and procedures to detect and prevent money laundering. FINRA Rule 3310 addresses AML obligations. In addition, FINRA Rule 2090, the Know Your Customer Rule, or KYC rule, requires firms to use reasonable diligence in regard to the opening and maintenance of every account to know and retain the essential facts concerning every customer and concerning the authority of each person acting on behalf of such customer. Technology is already being explored to centralize identity management functions such that once a customer identity is verified, the information can be shared with all network participants. Obviously, this would greatly streamline processes for broker-dealers and customers alike. It is likely that DLT technology will surpass regulatory changes in the AML, CIP, and KYC sectors. The FINRA report notes that the current rules allows a firm to outsource functions to third parties, but not overall responsibility. Accordingly, a firm could utilize DLT technology for these functions now if they can fashion internal controls and procedures that comply with the ultimate rule responsibilities. This will be a big hurdle, though. It'll be difficult. Related to customer data privacy, broker-dealers have an obligation to protect personal customer information as specified in Regulation SP. The rules also require that a firm provide an annual notice to customers related to the protection and sharing of their personal information. DLT by nature will include customer information and transaction histories that will be available to all network participants. Regulations as well as internal controls and procedures will need to adapt for this DLT technology to protect personal identifying information. Related to trade and order reporting requirements, FINRA regulates the trading and order reporting requirements for the over-the-counter markets, OTC markets, and requires certain reports to a centralized securities information processor for listed securities. DLT may soon be used for the facilitation of OTC markets equity transactions. This may involve tokenizing existing securities and trading on a different network. The FINRA Rule 6100 series, called Quoting and Trading in NMS Stock, Rule 6400 series, Quoting and Trading on OTC Equity Securities, Rule 4550 series for alternative trading systems, and Rule 5000 series governing offering and trading standards and practices would all be implicated. Related to supervision and surveillance, DLT networks will present new and unique challenges related to maintaining supervisory rules and procedures as well as surveillance systems themselves. This area includes the ability to review customer accounts and correct order errors. Like other areas of DLT technology, centralized systems available to all network participants are being developed that can perform some of these functions. Related to fees and commissions, Certain additional fees may be necessary for a DLT network, such as wallet management, key management, and onboarding, whereby other areas may reduce fees as centralization brings economies of scale. In addition, consideration must be given to the payment of fees to third parties that are not registered broker-dealers, but that provide DLT outsource functions. Related to customer confirmations and account statements, Exchange Act Rule 10b-10 requires firms to provide customers with certain records, including trade confirmations and account statements. DLT technology will change the flow and availability of this information. Related to the material impact on business operations, NASD Rule 1017A5 requires broker-dealers that undergo a material change in business operations to file a continuing membership application, or CMA, prior to implementing the material change. Many of the aspects of DLT technology will result in a material change, and broker-dealers will need to consider the need to file 1017 applications. Finally, related to business continuity plans, FINRA Rule 4370 requires broker-dealers to maintain business continuity standards and plans. Firms may consider the impact and must consider the impact of DLT technology on their plans and update them accordingly. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.